Good morning, everyone. Welcome to the Rome November immigration update in regards to all of the exciting changes that the government has put through for so many temporary visa holders at this time. This is some exciting news for many people who have been in Australia, some for a very extended period of time, but who will now be able to access permanent residency. That said, the changes are perhaps not quite as universal as we might have hoped, and we'll explore that in a little bit more depth as we go along. So what I might do now is just cut across to the slides and walk everyone through those changes. Now, if you do have comments, the chat window should be available for you, and you should be able to type any messages in there. I will be monitoring that as we go. I may not get a chance to come back until your questions later in the session, but please feel free to put any questions you may have in there. So thank you all for joining me today. We've described today's webinar as a small revolution. I think that might seem a little bit exaggerated, but for people who perhaps came to Australia a number of years ago with the hope of obtaining permanent residency, only to find the system change and that access to permanent residency sort of slip away, it really is a big deal. So this announcement has been pending since the Labor government came to power. It was announced as something they would do even prior to the election, but it's taken some time. It's taken almost 18 months for the government to push this change through. And as we'll see, the changes are reasonable in many ways, but just be aware that it's always worth getting professional advice in these scenarios, because as much as I have tried to accurately summarize the changes, the devil is in the detail, and unfortunately immigration law is outrageously detailed. So it is good if you go and ask about your personal circumstances, because not everyone is going to be affected in the same way, as we'll see. So we'll talk a little bit, first of all, about the background to how we got here. For those who joined us before, you'll know that I am a bit of a nerd for sort of the history and the development of the law, and I think that it's actually quite relevant to understand that in order to better understand what the government's trying to achieve today. We'll then move on to the regulations, looking at what the government has changed effective the 25th of November. In particular, there are three really key areas, I guess, or maybe even four really key areas for people who have that 482 in the short-term stream, or maybe even in the regional stream, some labour agreement holders. They are the changes to the qualifying period in order to apply for a 186 TRT, removal of the occupation lists and the occupation lists themselves being substituted by a reference to ANSCO codes, the changes to age exemptions for regional medical practitioners and high income earners, and then also just about renewing that 482 visa, which, when it first came into place, we were told would only be for one onshore renewal, and then you would need to go offshore. Okay, so that was a big barrier for many people. It has been somewhat mitigated through COVID on the basis of a concession where the government sort of let people apply for a third visa or a second onshore visa, but we've now had the removal of that pretty much entirely. So by way of, actually, I might start with some key terms just for those who aren't overly familiar. First off, the temporary skill shortage subclass 482 visa. Okay, so this is the main work visa in Australia. It is an employer-sponsored visa. It can be applied for between 1 and 4 years, depending on different factors, in particular the occupation stream and the period that the employer has selected. Okay, so there are multiple factors there. In fact, in some cases, it can be granted for 5 years for Hong Kong nationals. okay? And that occurs even if the employer asks for a 1 year period, okay? So this very simple example just goes to show how complex immigration can be. You know, you've got this rule 1 to 4 years, but then you've got a number of exceptions and you know, variations on that. Now, we will talk a lot about occupation lists. When the 482 visa program came into place in 2018, it was a really key part of that program that what had previously been sort of a universal occupation list in the ANZCO jobs dictionary was changed into multiple occupation lists with different requirements, with different purposes and different limitations in terms of things like access to permanent residency. This was one of the really critical changes in the 482 program. I disagreed vociferously at the time with the changes, both the way that they were put through and many of the decisions that were made around that. It was pretty clear from the start that removing a pathway to permanent residency for people on the short-term list would affect somewhere between 50 and 60% of all 482 visa holders. And, you know, in my opinion, it was effectively the creation of a guest worker program. The government, the former Liberal government maintained that that was the best course of action because they considered that these occupations were a relatively low priority for the Australian economy, and that, you know, the goal in the Australian immigration system is to attract the best people for Australia in terms of, you know, economic output over time, okay? That's essentially the Australian government position, and it's not even particularly a contentious one, okay? But it's all about how you consider what the best benefit to Australia means, in my opinion. So the short-term occupations were only eligible for a 1 or 2 year visa. It could only be renewed onshore once. And the purpose really was that people would come in, fill a skills gap for, you know, up to a period of sort of 4 years, and then they would leave, okay? The next occupation on the list is the medium and long-term list. It was for high priority occupations, and you could get a visa between 1 and 4 years. It could be renewed indefinitely while the occupation remained on that list. Okay, and I'll just pause there momentarily to say these occupation lists were never meant to be set in stone. They were meant to be reviewed pretty much every 6 months. In reality, we only ever saw 1 or 2 reviews of the lists before the COVID period, at which time, you know, any intention of reviewing those was basically abandoned. The list that we have now, which is the medium and long-term list, it is primarily focused on what I would call technical occupations or white-collar technical occupations like engineering, IT, healthcare, this sort of area, as well as a number of trade occupations. In contrast, the short-term skilled occupation list has a lot of what you might call general business roles, sales and marketing, HR, finance, strangely, even some teaching roles, okay? But there is sort of a different focus. And in theory, those lists are drawn up based on a lot of data from, you know, the Department of Employment and various other sources about labour markets in Australia. Finally, we had a regional occupation list, and this list limited people to apply in particular occupations to regional areas. Okay, so the idea was that, you know, in a major metropolitan centre, these jobs weren't really in shortage, but there was recognition that in regional areas it was a different ball game, and that employers might need those people. Now, initially, that regional occupation list was part of a subset of the medium and long-term list, which meant that there was a pathway to permanent residency. At some point in there, the department pulled a Swifty and essentially disaggregated the regional list from the medium and long-term list, and it became its own standalone list without a pathway to permanent residency. which was pretty brutal for many people who'd sort of gone into that thinking that there was. And the department's response was, well, that's because you could apply for a subclass 494 visa. Now, for those who don't know, a subclass 494 is a skilled employer-sponsored regional visa. It has had a very low level of take-up because of its lack of desirability. It's expensive, the requirements are high, you have to stay in a regional area for at least 3 years, and so do your family members. So the regional occupation list became a bit of a dead end, but was subsequently amended to include some COVID concessions to allow PR. Okay, so those are the three sort of key occupation lists within the 482 system. And then we have these two programs that are part of the 482 visa, but they sort of sit outside the standard program because they're by direct negotiation with the Department of Home Affairs. So a labour agreement can be either for an industry or for a specific company, and they're negotiated based on known shortages in the sector, and they may or may not include a pathway to permanent residency. So, for example, there are industry labour agreements in industries such as dairy, fishing. There used to be one in snow sports. There's a horticulture industry labour agreement. Basically, this is intended to create opportunities for employers in those sectors who have challenges getting workers locally, but the department wants a higher level of scrutiny than is applied to the standard occupations, okay, because they're occupations that are recognised as being below the standard skill level or receiving a relatively low income or known to have risks of exploitation, for example, in horticulture. The last one is a Dharma. The Dharma is negotiated between a regional authority, such as a council or a state government, and the Department of Home Affairs, or even multiple councils sort of coming together. And again, it's based on the needs, the labour market needs in that particular area, okay? And they are quite customised, and both labour agreements and the Dharmas can include what I'm going to call non-ANZCO occupations. Okay, for those who don't know, the ANZCO is basically a jobs dictionary defined by the Australian Bureau of Statistics. It was never meant to be used for immigration, but it has been used for immigration for many years now, decades, and it in theory sets out all the jobs in Australia. Problem is that the labour market has evolved over time. There are new occupations that didn't exist when these dictionaries were prepared. And in fact, if you cast a very critical eye over the ANZCO system, there are many occupations that just are missing. You kind of go from a farmer, for example, who is deemed to be skill level 1, like a manager or a CEO or another professional, and then you drop for the next level within the say farm hierarchy, you drop all the way down to basically an unskilled role. Okay, so for farmers, for example, to use the visa program, it's very difficult within the standard 482 program, and that's why there are these industry-specific labour agreements. Okay, so the ANZCO dictionary itself has become a big barrier and a big challenge to the system. Now, one thing that I haven't included there in key terms is the subclass 186 itself. Now, the subclass 186 is the standard employer-sponsored permanent residency visa. It has historically been considered sort of the natural progression from a 482. Okay, so from a 457, excuse me, under the previous program. And of course, that changed drastically when the Turnbull government introduced the 482 visa program. All of a sudden, that pathway to permanent residency was no longer guaranteed, and in fact, potentially completely blocked. There are two main streams within the 186 visa. There is the temporary resident transition, which is has a lower threshold on the basis that it's considered, because the person has worked for the employer for a period of 3 out of 4 years prior to 25th of November this year, that they would need less evidence of their ability in the occupation to apply. So it's something of a concessional pathway because you've already been in the job for 3 out of the 4 years. There is another pathway called the 186 direct entry. Now, this is for people who are already experienced in their field, who can obtain a positive skills assessment. A skills assessment is issued by an Australian authority in a particular occupation or industry, such as the Australian Computer Society or Engineers Australia. These bodies are recognised as being the experts in the industry, and so they have the ability to accredit individuals on the basis of their background, qualifications, and so forth. So to qualify for a 186 direct entry visa, you need a positive skills assessment and you need evidence of at least 3 years experience. Now, the changes that we are actually talking about today really only relate, whoops, scrolling my mouse the wrong way, really only relate to the 186 temporary resident transition stream. Okay, this is the concessional stream as I've described it, and the changes that have been made create a pathway through that stream for people on the short-term visa and some of the other streams as well. There is no 186 direct entry pathway for these people. There is no opportunity to skip ahead and apply sooner rather than later. You have to serve out your time on the 482 visa. Okay, so albeit that the government has increased the opportunities to access permanent residency, they have actually built in this requirement for 2 years full-time work. As such, people on the short-term visas still have a disadvantage over people on the medium and long-term list. Those lists still exist. They still operate for the 482 visa. They still operate for the 186 direct entry visa stream. So important to recognise that as beneficial as this is, it has very clear limitations that the government has chosen to implement. If we take a step back just briefly to the background, the history of the 482 and 457 visa program. 457 itself was implemented in '94 by John Howard, and it was designed initially for executives, senior executives to come to Australia and work. Now, you can imagine 1994, that's a while ago now, probably longer ago than I would like it to be, but this was really the start of sort of a big growth, a big increase in global mobility for professionals around the world. Before that time, people did move around, but it was a relatively limited cohort of people. And what we see over the sort of 20 years that comes from '94 is that the sheer number of people who are migrating for work, who are traveling on the basis of intercompany transfers or whatever it may be, just skyrockets. By 2017, the 457 visa program had been subject to numerous reviews, reports, many stories of exploitation and abuse. Okay, it was very high profile at the time, and the Turnbull government took the decision to cancel it on the basis that it had lost public support. And the decision was that it would be replaced with the subclass 482 visa. There was discussion at the time, is the 482 really just the 457 visa reborn? Is it just a version 2.0? And the reality is that to some extent, of course it is, because it is an employer-sponsored work visa. So it exists within similar parameters to the 457 visa program, but it had those critical differences that occupations were really the driving consideration, and the intention was that the occupation lists would be dynamic. They would change all the time. They would that would mean that, you know, as the economy decided we needed people in this particular area, those occupations would go onto the medium and long-term list, which I often refer to as the good list, and occupations that were no longer in demand would either move from the medium and long-term list to the short list, which I refer to as the bad list, or even just be removed entirely and would no longer be eligible for visas. Okay, so it was supposed to be a dynamic program. That never really came into place due to COVID and other factors. So when the 482 visa program came into force, we had this limitation on people in the short-term stream. They couldn't renew more than once onshore. Okay, so in theory, you're going to get a maximum of 4 years. That was a significant reduction from the previous 457 program, which could be anywhere from 1 to 4 years. And there was, of course, no pathway to permanent residency. The program ticked along. It had a number of issues. It had to be amended from the start. But by 2020, it was largely in place and everyone was more or less used to the new limitations. All of a sudden, we have COVID, borders closed, and a very significant period of difficulty in the economy for pretty much everyone. Through that time, the government introduced some limited concessions for STSOL visa holders based on this concept that they had worked through the pandemic and therefore they had earned the right to transition to permanent residency. Now, that might be a very nice way of presenting things. A more cynical perspective might be that the government was desperate for people to stay in Australia and they didn't want more people leaving because, the Australian government often primes the economy by bringing in new people, and losing people, of course, means there's fewer people spending money in the economy and so forth. So those concessions were put into place for renewals as well as for access to permanent residency for people who had worked for 12 months during what was called the COVID period. And then as we sort of emerge from COVID, we've got the election of the Labor government, the Albanese Labor government, which had, prior to its election, announced an intention to return to a system where all 482 visa holders would have access to permanent residency. Okay, so this is a big change. In theory, it's going to increase access to PR for about 50 to 60% of people who have 482 visas. And that change has been widely anticipated for an extended period. You can see May 22 to late November 23. It's almost taken 18 months for this to come through. And this is, from what I understand of the government's announcements and the government's sort of agenda when it comes to immigration and particularly employer-sponsored immigration, the first significant step towards a renewed system. And we'll talk about that a bit more as we go. 25 November, last Saturday, the migration amendment expanding access to temporary resident transition stream regulations came into effect. So these changes that we're talking about are already in effect, and people who had those short-term visas and even people on the medium and long-term list will now benefit from a shorter period of time to qualify for permanent residency. So let's have a look at some of those key changes. So I've classified the changes relating to the 186 into 3 key areas. First of all, there's this issue around the TRT occupation lists being removed for the purposes of the 186 TRT visa. Now, this applies to both 482 and 457 visa holders. Okay, so there are a few 457 visa holders still floating around for various reasons, and they will have the same benefits as the 482 visa holders. That said, the number, it must be very, very small at this point. It's probably a few thousand in Australia, I would guess. In terms of the TRT occupation lists, what has happened is previously the regulation said you must, if you apply, you must nominate. So this is in relation to the nomination, that's the employer side of the application. The employer must nominate, as part of that 186 TRT application, an occupation which appears on one of the lists which is approved for the visa. And previously that was only the MLTSSL with some concessions for STSOL and ROL. There were also pathways to permanent residency for the labour agreement visas and the DARMA for some labour agreements. Okay, that was negotiated by industry or by companies. And then there were pathways for DARMAs, again, negotiated on a sort of individual basis in terms of what the requirements were. Okay, and there's a question mark there, and I'll come back to that a bit later in the session. The qualifying period has reduced from 3 years out of the last 4. So the idea being that you must have worked for your nominating employer for 3 years out of the last 4 in order to qualify for the 186 TRT. That has now been reduced to 2 years in the last 3. So it's a pretty substantial reduction for people who are on the MLT SSL, and it is entirely new for this short-term cohort. One thing that I'll note about the changing period is that it has very different impacts on the employer and the visa holder. So for visa holders, this is a big opportunity. It's very exciting. For employers who have incurred expenses as a result of needing to source and employ people from overseas, whether that's things like relocation costs, whether it's the recruitment process itself, whether it is the visa and nomination process, okay? This is a shorter period in which they need to recover the costs that they've outlaid. Okay, so I think it's important for both employers and employees to recognize that they are not necessarily aligned in their interests here, and that whilst many people will be very excited that they now have a pathway to permanent residency, for employers it will pose a different issue, and they may not be as keen to push candidates through to permanent residency as quickly as possible, because they have to consider the impacts of people obtaining permanent residency on the costs that have been incurred. Okay, so it's just important, I think, that everyone involved understand that the parties here aren't necessarily in a position where their interests are clearly aligned. The last major change to the 186 TRT stream that I'll point out is a reduction in the period of time required to qualify for one of the age exemptions, particularly or specifically the high income earner exemption and the regional medical practitioner exemption. Now I'll just stop and explain the age exemptions a little bit. At the moment, in order to qualify for the 186 TRT, you must be under 45 if you're on a 482 visa. Some 457 visa holders will qualify under the age of 50 until the 1st of July 2023, to the best of my recollection, okay? That said, there are multiple exceptions to that for different cohorts, okay? So people in different situations will have access to permanent residency after the age of 45. They include people who are on a high income, okay? And high income it's sort of like an executive exemption, executive salary exemption. The high income threshold is set by Fair Work. It's what's called the Fair Work High Income Threshold, or the FWIT, as you'll see there. And it's currently about $167,000 a year. Okay, that figure is indexed each year, so it does increase each year. At this point, it's sort of increasing by around, I would say, around $7,500, maybe $10,000 a year. Okay, so this year 167, next year probably 175 or maybe 177. And in order to qualify under this stream, you have to have earned at least that amount as a base salary for the relevant period. Okay, so relevant period being 2 out of the last 3 years based on the reduction in the period to qualify. It can be a little bit tricky. So again, this is one of those areas where, you know, it's not safe to assume in immigration that, you know, oh yes, Fair Work income, okay, yes, tick. You really do have to drill down to some extent into the type of income. For example, you may be a medical practitioner who is earning quite a lot of money, but when you look at it, a substantial percentage might come from overtime, or it might come from shift allocations or various things like that that may not be able to be included. Similarly, some sales roles which earn a substantial amount of money will be above the Fair Work High Income threshold, but that's based on commissions and sales and other bonuses like that, and the base salary may be substantially lower. The base salary may be, $80,000, $70,000 with a very high level of commissions. So it is a pathway, but you have to be aware of the limitations. The other exemption that has changed is the regional medical practitioner exemption. It is for medical practitioners operating in regional areas. The name really says it all. You have to look at whether the area you are in is regional. You have to look at things like, have you had the visa for the required period? Again, it's one of those things where the devil is really in the detail, but the good news is that it will reduce from 3 years to 2 years if you are a regional medical practitioner and you meet the requirements. Okay, so that's very significant reduction really in that overall period of time. Now, let's talk a little bit about how the removal of the occupation lists from the 186 nomination operates. Okay, so essentially what is going on is that when the 482 regulations were set up, the regulations basically said you must, in order to qualify for this visa, you must nominate an occupation which is on a relevant list. And the minister had a legislative instrument which had the lists. For those who aren't aware, a legislative instrument is kind of, it's a way that the government can put in information that it knows it will want to change regularly or easily. So, for example, with this idea that the occupation lists were going to be responsive to the economy, responsive to labour market shortages, rather than put it into regulations, what they did is they had a legislative instrument that could be updated essentially at the minister's discretion, and they could move the occupations around. Okay, and what has happened as a result of the changes on the 25th of November is that the requirement to nominate an occupation on the list has just been removed wholesale. Okay, and what remains now is a requirement that the occupation must be listed in ANSCO, and you must be nominating the same occupation unit group, that's 4-digit ANSCO code, as the original 482 nomination. Okay, so I'll just explain those different parts quickly. So if we're looking here at the second last dot point, primary occupation requirement becomes that the occupation is listed in ANSCO. So we've spoken about the ANSCO jobs dictionary. We've said that there are a whole bunch of different occupations that have been determined by the Australian Bureau of Statistics. And historically, when you go to apply for a 457 or a 482, you say, I fit into this occupation category. I am a chef. I am not a cook. I'm going to nominate chef because my role matches the job duties that are listed in the ANSCO jobs dictionary for a chef, for example. Now, one of the things about that is that the ANSCO system has a hierarchical organisation. The lowest level is the individual occupation, and the next level up is called a unit group. And what unit groups do is, in theory, they classify closely related occupations. So a really good example is baker and pastry cook are different occupations, but they are listed in the same unit group because they rely heavily on very similar skill set. Okay, and so basically, if you've originally been put forward as a baker, and then at the time that you're going to lodge a 186 nomination, your role will be as a pastry cook because you've moved from one side of the kitchen facility to the other, and you've gone from making pies and now you're making cakes or whatever it might be. You can nominate a different occupation provider that's in the same unit group. Now, this concept is nice, but it leads to a lot of problems because of the way the ANSCO dictionary is structured. For example, a cook and a chef are not considered closely related. Okay, so it's its own problem, and it presents its own challenges. But broadly speaking, the requirement is no longer that the occupation is on one of these lists specified by the minister, merely that it must be listed in the ANSCO dictionary. Okay, and we will again come back to that later. Oops. Now, I just wanted to share a list of occupations that are quite popular in the STSOL stream, or the short-term list. You can see that there's just a whole heap of them. There's about 200. As I say, 50 to 60% of people who are on 482s probably in one of these occupations. And they're not just, I mean, people make dismissive comments often about immigration and sponsorship and that sort of thing. I remember when the 482 visa program was implemented, one of the changes that sort of was mocked and ridiculed was that they decided to remove, I think they decided to remove goat farmer, and they decided to remove antiques dealer. And people were like, oh, goodness gracious, why would you ever need an antique dealer or a goat farmer? Well, I can tell you right now that the price of goat meat is higher than the price of lamb, and that goat has become a very popular sector for the primary industry. And there really can be a business case for these occupations, even if it's not related to your job or your role or your world. The fact that some of these occupations are on the short-term list really speaks to how challenging preparing a system such as this can be. And I'll point out that primary school teacher, middle school teacher, and school principal are all there. And I think we would probably all be aware of the gross shortage of people in those professions in Australia. Similarly, enrolled nurse, I believe, is on this list, as is resident medical officer. Okay. Now, the idea that those occupations are not in the long-term interest of Australia in 2023 is pretty highly controversial. So very good from my perspective to see that these people have a pathway to permanent residency. And I'll also point out that some occupations were considered so low on the priority list that they were moved to the regional occupation list, and in particular anaesthetist. Okay, and the idea in 2023 that we have too many anaesthetists is pretty laughable, I think. But all of those people in all of those occupations will have a pathway to permanent residency now, okay, provided that they complete that 2 years in the last 3. And that's what this is talking about. So prior to the 25th of November, the regulation said that during the period of 4 years, immediately before the application is made, the identified person held one or more of the following visas for a total period of at least 3 years. Okay, and that has now simply been changed to say during the period of 3 years immediately before, the person held one of the visas for 2 years. Okay, so it's a very simple, straightforward change, uncontroversial in many respects. We've already spoken about this to some extent. There are multiple age exemptions. Now, regional medical practitioner and high income visa holder are only 2. There are others for New Zealand citizens on a 444 visa. There are senior academics and employers, scientists working at a research laboratory, a Commonwealth or state government research laboratory, can also have exemptions, okay? But in this case, it is the regional medical practitioner and the high income earners who are being reduced from 3 years in the last 4 to 2 years in the last 3. Okay, so again, the change itself has occurred in quite a simple fashion. It's quite uncontroversial. Obviously, there is always devil in the detail as to, has this person worked for 2 years in the last 3? Do they meet the requirements of the provision? But the period itself has reduced. Okay, so that is very good news for people in that situation. And I'll note that, for example, these New Zealand citizens and family relatives, which is the 461 visa, they were already at 2 out of the last 3 years. Previously, the system was 2 out of 2 years, and it was increased in the last decade to 3 years. Okay, so this is more of a return to the way things used to be. Now, one of the things to point out here is that, obviously these pathways to permanent residency through the 186 TRT have changed, but it's not just that. The 482 visa can now be renewed. The 482 STSOL visa can now be renewed indefinitely based on the changes, okay? But that short-term stream in the 482 remains for the time being, okay? So you can still only get the 2 years. It is not a perfect resolution to this problem. It is an interim solution, essentially. And we know that the government has announced an intention to make very significant changes, which it's described as generational changes, the biggest changes in the last 30 years to the visa program, okay? And really, this is just meant to be a sort of step prior to those big changes coming into place that will create greater alignment with the system that they want to implement. Whether that will ever happen, I'm probably more skeptical than I was 12 months ago, but we will see, okay? But this is really only intended as a first step to a much broader program. The 186 TRT nomination now has a, visa and nomination now have expanded grounds for refund, okay? And that essentially occurs where the person doesn't meet the period of time required for the nomination or the visa, okay? And that is a good thing. Refunds in immigration are notoriously difficult. The grounds for a refund are incredibly narrow, and fundamentally, I think that Australia has to look at its pricing around visas. I think it is increasingly uncompetitive. For many families of 4 or 5 people, visa charges for a 482 or a 186 can be between $10,000 and $20,000. That's a huge amount of money. And if you apply and make even a very minor administrative error, you can be in a situation where you won't get your money back. Now, I just think that is completely unjust. And there are certainly other jurisdictions around the world, such as Canada, where if your application is refused, you get the bulk of your money back. Okay. I mean, if you're paying $5,000 to become a permanent resident and you don't get to be a permanent resident, why are they keeping the $5,000? Okay, but this is one of the other issues in the immigration space. Good to see that in this particular case, the refunds have been provided for there. Now, I mentioned earlier that there are some limitations to what's been done, and I applaud the government for seeking to expand these pathways, but I'd point out that there are a couple of issues that have perhaps slipped through the cracks or not been specifically addressed. Okay, and I'll go through them one by one. Non-ANZCO occupations. We talked about how the removal of the occupation lists as a criteria for the 186 nomination mean that you don't need to have an occupation on the list. But what it does say is that you must have an ANZCO occupation, and that occupation must be listed in the current version of ANZCO. Okay, there are a number of recent versions of ANZCO. It has been updated in the last 2 to 3 years a couple of times, which is far more than it had been for a decade or more. But if you go and you look at the occupations that are listed in some of the DAMAs and some of the labour agreements, they are not ANZCO occupations. They use a generic code which has been determined by the Department of Home Affairs, 070499, I believe, which is not a standard ANZCO occupation. What does this mean? Well, essentially it means that anyone who is in those occupations is restricted to whatever the conditions are in the DAMA or labour agreement, okay? And that will vary by agreement, but it's something to be conscious of, okay? if you are one of those people, or if employees with your business fall into that category, you really need to have a look at whether or not they will qualify. My interpretation is they do not, and you'll need to consider whether whether the DARMA or labour agreement that you have in place gives those individuals, those employees, the pathway that is best for your business. Because certainly there have been a large number of labour agreements negotiated, particularly under the Liberal government, which did not allow for a pathway to permanent residency. The second issue here is not so much something that was missed as something that was deliberately left out. The department did not change the requirements for the 186 direct entry. You still have to be in that MLT SSL occupation list. The role has to meet any caveats, and the visa applicant has to meet the skills assessment requirements. Okay, so essentially the 186DE remains a more favourable pathway in many respects, and people in the short-term stream just simply do not have access to that. Okay, so it's less of a it's less of a slip and more of a deliberate choice to control that access to permanent residency for people in those streams to require 2 years full-time work. And just for everyone's information, that itself has limitations, because there are certainly situations where visa holders may be working with exploitative employers. They may be unhappy with the situation for whatever reason, but to obtain permanent residency at this point, they would need to transition to another employer, and they would need to complete at least 2 years full-time work on a 482 visa. And depending on your age and various other factors, that just may not be possible. Okay, so there are some limitations there around these different factors. Next one, and perhaps the most important of these to be aware of, both for people who are migration professionals as well as people who are employers and visa holders. Now, the requirement to qualify for a 186 TRT is that you must have worked in the role for at least 2 years, Now, if a 482 in the short-term stream is granted for 2 years, is it technically possible to qualify on the basis of completing at least 2 years? My understanding is that the technical answer to that is no. It is not possible to meet that requirement in a 2-year period. And so what the department has done to mitigate that, and the perhaps what might be considered unreasonable burden of additional costs and administration, because you're going to have to go back and reapply for the whole new nomination, new visa that has to get and then you apply for the 186. The department has policy, and when I say policy, what I mean is that the department's internal instruction manual to its case officers, which is provided to migration professionals through a subscription. This policy says on this particular point that where the person has worked almost 2 years, that it should be considered sufficient and it should be granted. Okay, now there's a couple of problems with this. The first one is that if I'm advising you as your legal advisor, it puts me in a very challenging position where I say the law says you don't qualify, but the department says they will grant it. Okay, that's very difficult for everyone, because you're being pulled in 2 different directions, and you're relying ultimately on the department to do what it says. If, for example, that decision is refused on the basis that it doesn't meet 2 years, okay, you can't appeal that decision with any prospect of success, because what the department is actually doing is approving the visa without the legal authority to do it. So if you go to a tribunal or a court and you say the department said they would approve this, but they didn't, all they can do is look at the law and say, well, the law says you can't get it. Okay, so there is a really significant element of risk here, and it's a very serious matter to consider. The other issue is that the policy there doesn't say what almost means. Okay, does almost mean that the person has worked for 1 year and 364 days? What if you're a week short? What if you're a month short? How short? How close is almost? There is no definition of that. Okay. And so the reality is, if you have a situation where someone has come into your business They've been granted a visa offshore. It's taken them 6 weeks to get to Australia. And, so when you look at it, they've actually only worked for you for 1 year and 10 and a half months. You're almost certainly going to need another 482 short-term visa. Okay, so that's something to be aware of. The alignment of these periods and the visa duration do not match, and there is significant issues, significant risk if you choose to progress, even though the employee is under the 2 years. So just quickly, as I see, we're getting close to time, a summary of the key changes. So for the short term 482, we've gone from a situation where you could only renew once onshore to unlimited renewals. The qualifying period for the 186 for people who have an ANSCO occupation has gone from 3 and 4 to 2 and 3. Occupations no longer need to be on that medium and long-term list or concessions based on STSOL or ROL. They only need to be in the ANSCO dictionary, noting that potential concern around non-ANSCO occupations in labour agreements and DARMAs. And then the age exemption for regional medical practitioners and high income earners has reduced from 3 and 4 to 2 and 3. Okay, these are positive changes. I'm very glad for many of the temporary visa holders who have received the benefit of, or who will receive the benefit of this change. People don't typically come to Australia desiring to work here for 2 to 3 years and go home. Most people who come want to join the Australian community and become part of the Australian community. And, in my personal opinion, I think that that is consistent with, Australian values. Giving people the opportunity to do so is consistent with Australian values of multiculturalism and so forth. So I applaud this from a humanitarian as well as an Australian values perspective. But it is important to note that this is really only the first step in a potentially wide, potentially sweeping reforms. And just on that note, okay, so as a sort of concluding remark, the changes that have been proposed by Labor, we don't have the detail, but the intention is to make them very sweeping, very significant. The government is in a tricky position in November 2023. Rising costs, inflation, housing pressure are creating quite a lot of negative media and negative public opinion. And immigration is often held up as being responsible for these factors. Immigration plays a role, there is no doubt, but there are other factors as well, things like housing policy, etc. And many of the people who are coming into Australia to perform work on a 482 visa are doing things that we really need done. Doctors, nurses, engineers, all of these different things, personal care assistants, okay? So this is something that the government really needs to balance, and it is going to be in a really tricky position over the remainder of its current political term to try and achieve its goals of sweeping immigration reform at a time when things are so difficult and so tight in the economy. I'm concerned that that will mean that there is a lower chance of these changes actually being implemented, but we will see. The government really only has another 18 months to do this. And, there is a lot of opportunity in the immigration system to improve the life for Australians, to increase the economy and so forth, but those benefits need to really be balanced against the economic challenges. And I think that that is something that, even the most competent government would struggle to do. Okay, so thank you everyone for your time. Very happy to take questions now. I understand that the chat feature is not working. However, the Q&A function may well be working. So if you had any questions, please feel free to drop them in now, and I will take some time to answer as many as I can. Oh, 16 questions. So my apologies. Okay. So James Scott, test. The test worked, James. James, I can see your question. Thank you for your if I hold a 482 partner visa and worked in a skilled occupation with a positive skills assessment, can I ask my employer to apply for 186 TRT even though they are not my employer? Thank you, Shamil, for your question. No, you cannot. A secondary 482 visa holder cannot apply for a 186 TRT. They can apply for a 186 direct entry, provided that their occupation is on the relevant MLT SSL list. But if it comes to a short-term occupation, you would need to become the primary sponsor and you would need to do 2 years full-time work. Okay, so Shamil, it will really depend on what occupation you're in and whether or not you're in a medium and long-term occupation. Normal requirement for the 482 is to complete 2 or 3 years within 5 years. Thing is, I see different websites that can be flexible. How strict are they being within the last 5 years? Okay, so James is asking a question about the 482 visa rather than the 186 visa. James, the answer is that the department's policy says that at least 2 years work experience, you have to have 2 years work experience minimum if you have the qualification to obtain a 482. The law does not say it has to be within the last 5 years, but the department's policy does. And that puts us in a tricky position because if the department then refuses it, you may have the opportunity to go to appeal, and the appeal will likely go in your favor on the basis that the law doesn't say anything about 5 years, okay, the experience being in the last 5 years, but the appeal process is likely to take 2 to 3 years. And unless you're in Australia with work rights, it's very unlikely that it is a feasible option because no employer is going to be able to wait 2 to 3 years for that appeal for you to get a positive outcome. Do we need, Shanika has asked, do we need a skills assessment after we work on the 482 visa for 2 years? The answer, Shanika, is essentially that if you are applying for the 186 temporary resident transition, you do not. If you are applying for the 186 direct entry, which we haven't really been talking about today, you do need a skills assessment. So at the moment, you need a sponsor. Shanika has asked, do you have to have a sponsor once we've worked on the 482 for 2 years? The answer is yes. At the moment, in order to qualify for a 186 temporary resident transition or direct entry, you do need an employer. And as part of that nomination, you need to be offered at least 2 years full-time work, and you need to agree that it is your intention to do that. Now, one of the things that I believe may occur in future in these bigger picture changes is that the government may move to a system where the 186 is not specifically employer sponsored. We've seen a similar situation with the 191, which is the permanent extension of the 494 visa. And I think it would remove a lot of the government's concerns and concerns amongst academics and others about exploitation, okay, if that need for sponsorship is removed. However, it's unclear whether it will ever happen, okay? It's just a maybe. For a general practitioner on a 482 TSS visa, can you apply for permanent residency with limited registration, or do you need general or specialist APRA registration? The government made a change in February of this year that medical practitioners can apply with limited APRA registration. There is no limitation on that any longer. For a GP on a 482 TSS, what is the minimum income bracket? That's a tricky question, Swapna. It will really depend. You have to be paid what is market rates. What market rates actually constitutes will depend on the situation. I'd recommend that you get in touch with me directly to discuss that more. I think we've answered the question about the Anonymous attendee, my question is that if you're on a 482 for 2 years and about to complete your time, then will that person be eligible for TRT? And if yes, when should it be applied? So essentially, yes, after 2 years full-time work on the 482 visa with your sponsor, you will qualify for a 186 TRT visa. And it can be applied for at any time after the 2 years. Daniel asks, does time working for your employer before your visa grant count towards the 2 years? No, it does not, James. I'm very sorry to say that it commences effective the date of the 482 visa approval. Okay, so when that 482 visa is approved, boom, the clock starts ticking. You need to do 2 years full time after that date to qualify. Swapna asks, to get a 186 TRT, do you need English? You do not need English if you can demonstrate at least 5 years of schooling in English language medium for the 186 TRT. What about for skills? Okay, so anonymous attendee has asked, what about an occupation that is below the standard 482 occupation list, okay, outside the standard 482 occupation lists in terms of skill level? So just for people who aren't perhaps that familiar, we can say there is a professional level in ANZCO that requires 5 years full-time experience or a bachelor. There is a paraprofessional which requires 3 years full-time or an associate degree, which is like a 2-year bachelor degree. And then there are trade occupations which require a Cert 4. And then below that, there are other occupations which might only require a Certificate 2 or a Certificate 1. Okay, normally Certificate 2 and Certificate 1 level occupations simply do not qualify for a 482 visa because they're not on any of the occupation lists. Okay, but that said, there may be scope to get a 482 visa under a labour agreement or a DARMA, which is in ANZCO, but is below the standard, is outside the standard occupation lists, okay? And barista would be a good example. Truck driver would be another, okay? The question is the occupation in the ANZCO dictionary? If yes, and you've been on a 482 for 2 years, you'll qualify as a general statement for the 186 TRT, okay? Asterisk, terms and conditions apply. But the issue that I was speaking about when I was talking about non-ANZCO occupations is that in some cases the department and whatever organisation it is, whether it's a state government, a local council, they've created occupations that don't exist in the ANZCO system. So one might be like a horticulture supervisor, right? It doesn't exist in ANZCO, it's just not there in the dictionary. But there was a perception from the parties at the time that there needed to be an occupation which exists on farms, which corresponds to this. And what they did was they wrote their own, but it's not in ANZCO. And so those occupations are the ones that don't meet the new 186 TRT requirements, okay? And for those type of occupations, you need to go back and look at the original agreement and see if there is a pathway to PR. And if there is not, then potentially you need to look at negotiating a new labour agreement, variation to a labour agreement, or something similar. We've already responded that there was no changes to the 186 direct entry. Oh, questions. Do you need police certificates from your home country? Yes, for a 186 you need a police certificate from your home country. Akil, what happens if you've been working? Okay, so Akil, your question is very similar to Daniel's. What happens if you've been working for your employer for an extended period, but you've only started on the 482 recently? Akil, you need to do the full 2 years. Okay, you need to do the full 2 years on the 482. So the clock starts once that 482 visa is granted. Whoa, okay. Thank you, Kathy. Very happy to share a copy of the presentation. Just reach out to me. Rebecca Stevens, will there be more age exemptions? I initially thought that there would be, Rebecca, but I no longer think so. And that probably comes as a result of discussions with people in the Minister's office. And I think that essentially there is a relatively hard line being taken on this idea of maximising people's economic output through the course of their life. For those who aren't immigration nerds, essentially the pathway to permanent residencies are decided based on recommendations by different government and non-government bodies. And the key aim is very clearly stated as, economic benefit to Australia. Okay, that's different from some other countries around the world, but in Australia, it's like, we want to benefit. How are you going to benefit us? Okay, that's the reality. Whether it's nice or not is a different question. For the age exemptions, whilst people are working longer and longer, what the Productivity Commission recommended in 2016, which was sort of adopted, was that you need to look at the cost of Medicare over the course of someone's end of life, is the nice way of putting it. And that cost is very significant. And essentially, unless that person is going to, in some way, repay the costs to the Commonwealth through tax and other means through the course of their working life in Australia, then they're not going to be a net benefit to Australia. I think that's a very short-sighted way of looking at it, but that's the current position, as I understand it. That's sort of the most recently accepted policy argument. And so, no, I think more age exemptions is unlikely. And I also think it's unlikely to see a rise in the age to 50 at this point. I might be wrong, but that's my position at the moment. Kamal asks, do the 2 years start from the date of nomination approval or the date of actually doing the job? The date of actually doing the job, Kamal, which is why it can be particularly troublesome for people who are, offshore or have even a notice period in Australia, right? If you've got to serve out a 4-week notice period, so you don't start with the new nominating employer until, a month after the visa approval, then that's just not going to, that's not going to work. And you need to apply for a new 482 visa for, 1 year so that you can get beyond that 1 year and 11 months. Okay. Fuad asks, is it possible for a doctor to work for more than one employer in 2 years and apply for ENS through the latest employer? Yes, Fuad, the rules for doctors are different. Okay. And as I said before, you need to, you really need to get specific advice about your circumstances. There are exemptions for doctors to work for multiple employers, but it's just a little bit tricky. And, I can't give you details now because it depends on your circumstances. Justin, self-employed as a counsellor, 50 years old, outside Australia, would meet high income. Is there a path for me to become a permanent resident? Justin, it's very challenging to say. Employer-sponsored visas are based on an offer from an Australian employer. In some cases, it is possible for people to open a business in Australia and come in and self-sponsor. The Department of Home Affairs doesn't particularly like that, okay? But it really depends on what they perceive as the value you're going to bring. Okay, and what I mean by that is they have said in the past, if you're going to open a car wash, then we don't consider that to be high value. If you're going to open an IT technology company that's going to employ 100 people and do X, Y, Z, then that's a different story. So if you are a counsellor, I think you would have to be very careful about what you're doing, and I think the chances are relatively low unless you can find an offer from an employer in Australia above that salary. I think that looking at opening your own would be very, very difficult. Duan, teacher in a tutor on a 482 visa, both working at the same school, are we eligible for permanent residency? It's going to depend on your occupation, how long you've been in the job, whether there's a pathway to the 186 DE or TRT. So Duan, I recommend just reaching out to me. I know you've contacted me recently. Just reach out to me and we'll look at that. Okay, good question from Sanyam. I've done 1.5 years on a 482. I have a student visa now that I hold with my wife. Do I have a chance to go back to the employer and finish the remaining 4 months? Does it have to be within the last 3 years, or can it be within the last 5 years? The answer is in the language used in the relevant provision in 5.19, which says, gosh, can I remember it off the top of my head? Probably not. Where is it? I might struggle to find the specific answer for you here, I'm afraid. But essentially, it has to be 2 in the last 3 years, and it doesn't necessarily have to be. Let me have a look. I'm going to have to take that one on notice. My understanding is the answer is no, but there are very limited circumstances where you can sort of have time coming and going. Okay. Age exemptions for regional practitioners. I'm not sure whether it includes resident medical officers, Sharon. I would need to go back and look. I'm sorry, off the top of my head. So if you're applying under the high income, Nita asks, do I need to be on the high income range for 2 years before I qualify for PR? Yes, that's right. You need to earn that salary for at least 2 years. Kushbu asks, there are several employers who have skills assessment exemptions for the 482. How can we access more information about such employers? I'll have to take that question on notice, Kushbu. The age exemption for the high income earner is equivalent to the Fair Work high income threshold, which is 167,500 base salary at the moment. Shanika asks, when the 482 visa expires after 2 years, what's the visa option to stay in Australia until we apply for the 186? The answer, Shanika, is you need to apply for another 482 because of that requirement that you must have had a 482 visa for at least 2 years. And at the time you apply, you must have either a 482, a 457, or a bridging visa for one of those, or a 186, 187. So you need to go from 482 to 482. Nita, I'm not entirely sure whether physiotherapists with limited registration qualify. I would need to look at it. Shamil, the answer was no. You need to be the primary visa holder for the 2 years on the 482. Charles, it's different for medical practitioners, okay? So need to come back. Need to come back and talk to me about that, Charles. My idea is to try and get a 482 visa in the short-term stream, but I don't qualify under the 2 years. Anonymous attendee, I think that's a tricky question and it requires specific advice. This isn't really the forum for specific advice like that. James, I would need to look at the specifics of the role. Hi everyone. Okay, I think we've got a lot more questions here. Unfortunately, I'm not in a position to continue. Thank you everyone for attending. Really appreciate your time. It's been great sharing these positive changes with you, and I hope that we've got more positive news coming up. Please, if you are interested, subscribe to our website. Really appreciate your time. And if you've got further questions, please, you can book a consultation through our website or send us an email. Thank you, everyone. Wishing you all the best and have a great day.